Good morning, everybody. We're just waiting for a few more folks to jump on here. I see the participant ticker is still going up. So we'll give it a few more minutes for folks to join, and then we'll get started. All right, let's get going. Good morning and welcome to this month's edition of the New Hampshire Tech Alliance HR Exchange. This is a program that is brought to you jointly by New Hampshire Tech Alliance, as well as She and Finney. My name is Brian Bouchard. I am a partner in our Portsmouth office, and I'm thrilled to be with everybody this morning. This morning's presentation, as I'm sure everybody knows because you signed up for it, is about WARN and layoffs and RIFs and the legal pitfalls to avoid with layoffs and furloughs and organizational changes. Before we get into the body of the presentation this morning, a few general announcements about our schedule and then about how to make sure that you get SHRM credits for this. Next month, on December 14th, we're going to be doing our annual presentation on the top 10 wage and hour violations. Jim Reedy from our office is going to be doing that presentation. That is, I think, one of the best presentations that we do. That list every year doesn't change often, which means that these violations are repetitive and something that every employer should be looking at and trying to fix. On January 11th, we are going to be doing a presentation on financial wellness, both for employees and for the employer. And Valerie McClendon from Boston Wealth Management is going to be conducting that presentation for us. And on February 8th, we're going to be doing a presentation on policies and preventive measures to avoid sexual harassment in the workplace. And our newest member from Cook Little, joining She and Finney, Jennifer Mackel, is going to be doing that presentation for us. As I mentioned earlier, if you are attending this and you are doing this for SHRM credits, you are eligible for SHRM credits. There is a slide at the end of my presentation with the code needed to submit credits for this presentation. Also, we are recording this presentation, so you can watch it again later. And at the end of the presentation, we're going to be distributing the slides to everyone who attended, so you have a copy for your own personal use as well. One last housekeeping matter. While I am a lawyer for She and Finney, this presentation is intended for educational purposes only. It is not intended to substitute for legal advice and is not intended to be any type of legal advice. With that out of the way let's get going here. Now, you should see on your screen a QR code as well as a link if you want to use that. We're going to try and do this restaurant style during COVID. If you go and scan that link, it should bring you to a website called Poll Everywhere. You'll have to accept cookies. You have the option of putting in your name, put it in, don't put it in, totally up to you. And what that is essentially a polling website. If anyone has ever done a presentation on Zoom for an hour, you know that probably around the 15-minute mark, you kind of feel like you're starting to lose your mind talking to yourself. So what I've done for this presentation is create a series of questions to try and make this as interactive as possible and to keep everybody engaged and to keep things moving. So that's going to take you to a website. Keep that open throughout the entire presentation. I have this slide in the presentation at another point, so if you lose it, you can jump back in. I think someone from our marketing office is going to try and put the link in the Q&A or the chat system. So that'll take you there, and it'll take you to an opening question, and you can just populate the answer as you would like. So the first question is, assuming everyone's been able to get in, is as an HR as a people operations professional, what single word do you associate with RIFs? One person put difficult, one person put layoffs. Horrible. It's another good one. Budget. Keep them coming in, and the slide will keep populating. So what this is a word cloud where the most commonly used word is the one that shows up the loudest, so to speak. And the ones I'm seeing here that the loudest is sad, painful, and horrible. And I think that's absolutely true when it comes to these types of issues. You as people operations professionals are on the front lines of this, and you're not in the finance office just looking at the numbers and trying to crunch numbers. You have to deal with the human element of this, and you have to deal with the legal side of this. And it's an immense challenge. And I'm sure everyone has had to deal with a RIF or a layoff at some point. And I'm hoping that this presentation can help with the legal side of things, and to make that smoother for everyone when you have the unfortunate situation of having to do a layoff or having to do a reduction in force or having to do a position elimination of some type. So with that, let's get going. Today's agenda, we're going to be talking about WARN, the Federal Worker Adjustment and Retraining Notification Act. We're going to be talking about severance agreements a lot and best practices to use for severance agreements. We're also going to be talking about wage and hour compliance in the context of layoffs and RIFs. And we're going to be talking about RIF strategies. We are in a strange economic climate right now, where some of my clients have done RIFs months ago, large ones and large reductions in pay as well. Those in the venture capital space, anyway, I've seen financing and the market dry up a little bit, so they conducted RIFs. Those in the financing space right now are starting to see those similar constraints. And then we have other manufacturing clients that still can't hire all the employees they need to meet. So the economic climate is running the gamut, and I don't think I've seen anything like it, where some people are doing RIFs and other people are still strained for hiring needs. WARN is, I think, the seminal act when it comes to doing any type of layoff or any type of RIF. It's a statute from 1988, and the purpose is to provide advance notice to employees of an impending job loss. That's the basic gist. But it only applies to select employers, and coverage applies if you are an employer with 100 or more employees at the time of the RIF. And employee here is defined very carefully. It does not include part-time employees, and a part-time employee for the purposes of the statute is anyone working fewer than 20 hours a week, or anyone who has been on the job fewer than 6 months out of the 12 months preceding the date on which the WARN notice is required. And so I just mentioned WARN notice. Let's talk about what the WARN notice is. The notice is exactly what I was describing. It's a notice that you have to provide to employees who are going to be terminated or laid off or receive an employment loss. And you have to give them a 60 days notice before that event transpires. And the events that we're talking about here are carefully defined under the Act. One is a plant closing, the other one is a mass layoff. Again, these are carefully defined. I'll go through them briefly just for context of today's conversation. Well, the plant closing is a permanent or temporary shutdown of a single site or a single unit within a workforce if the shutdown results in an employment loss during any 30-day period for 50 or more employees. Again, employees are talking about full-time employees, not part-time employees. And we're going to talk in the next slide about what constitutes employment loss. It isn't just someone who gets laid off or terminated. It can be other things as well. A mass layoff is an employment loss at a single site of employment during any 30-day period that is not a planned closing and affects at least 33% of the full-time employees and affects at least 50 full-time employees. Or a mass layoff is employment loss at a single site that affects at least 500 employees. Okay, so if you have a manufacturing facility in New Hampshire and you have 1,000 employees, 600 are getting laid off. It doesn't matter whether that's 33% of the workforce or not. You're going to have to provide WARN notices because you reached the 500 employee threshold. Employment loss is, again, carefully defined, and it's really three things under the Act. It's an employment termination other than discharge for cause, a voluntary departure, or retirement. So if you have a voluntary retirement program and people are taking advantage of that program and retiring as part of a RIF and they're retiring voluntarily, those people do not get swept up into the count of what would trigger a WARN event. Employment loss can also be a layoff exceeding 6 months. So we're gonna shut the plant down for 7 months here, and that's going to result in a job loss for the employees because it is more than 6 months. And finally, an employment loss can be a reduction in hours of work of 50% for employees that is going to last 6 months or is expected to last 6 months. So again, employment loss can be more than just having to lay off people. It could be some reducing hours by 50% for the requisite number of employees at a single job site. There are exceptions to warn. Many people have probably heard about them during the COVID-19 pandemic when it was at its peak. But here are three of the exceptions. There's also two exemptions that I'll talk about as well. One is the faltering company exemption. And that is the company is on the brink of financial collapse. It is actively seeking new capital to stay afloat, and giving notice would ruin the opportunity to collect that capital. Okay, so if a bank knows that you just provided warn notices for everybody, but you need those employees to meet production demands, a bank is going to be less inclined to actually give you the capital needed to stay afloat. So in that type of situation, a company is not required to provide warn notices, giving employees 60 days notice of a planned closing or a mass layoff. The second one is unforeseeable business circumstances. Look, things happen all the time, and there are circumstances in which it may not be possible for an employer to foresee a mass layoff or a plant closing. These types of things generally happen where you're a manufacturer, for instance, and your largest company, your largest client files for Chapter 7 bankruptcy, okay, and they're not going to buy any more product for you. Well, that obviously has an effect on your needs down the stream and may result in you having to do an unforeseen RIF quickly. And finally, a natural disaster. That's a closing or a layoff that is the direct result of a flood or a natural disaster, earthquake, drought. Classic example here is Hurricane Katrina, right? You're not going to be able to open for business for months because of that. And of course, the federal government isn't going to require any employer to provide warn notices in that type of situation. Obviously, the best practice is to avoid having to rely on these exemptions where you can. Now, going back to COVID, because everyone loves talking about COVID, the Fifth Circuit has held recently that COVID-19 does not constitute a natural disaster. So to the extent any employer relied on that previously and then maybe got away with it, just keep that in mind for the future in case there's an unexpected surge. The Fifth Circuit did not address, however, whether COVID-19 would be an unforeseeable business expense. There are federal courts that have ruled that COVID-19 was an unforeseeable business circumstance, not expense, but that hasn't gone up to any court with significant precedent yet. As I mentioned, there are also two exemptions for COVID. Two exemptions for warn. One is a plant closing that results in a strike or a lockout. Okay, you're not required to provide warn notices in that situation. The second is if you hire workers on a temporary basis, with the understanding that their employment is going to be limited to the duration of a facility, of a specific project, or a specific undertaking. Think of a shipping logistics company that hires hundreds of employees during the holiday rush, and then is going to be terminating those employees at the end of the season. Those employees come in knowing that their employment is going to be limited and they're not going to be required to receive COVID notices. Warn notices. Query whether warn would apply anyway in that situation because they're going to be considered part-time employees because they're employed for fewer than 6 months out of the year. There are states that have mini warn laws. New Hampshire is one of them. And New Hampshire's is fundamentally similar to its federal warn counterpart, but there are a few differences, both in what is considered a plant closing and a mass layoff, and in the penalties. And that's where the rubber really hits the road here. So plant closing for the purpose of New Hampshire warrant is an employment loss. Again, those same three criteria that we talked about before, affecting 50 or more full-time employees, okay? A mass layoff is an employment loss affecting 250 employees in the aggregate. The federal warrant counterpart is 500, or a mass layoff is an employment loss affecting 25 employees if they constitute 33% of the full-time workforce. So the New Hampshire mini warn statute brings the threshold down a little bit for what qualifies as a mass layoff. The penalties for warn violations can be rather significant. First, both in the federal and mini WARN counterparts, an employer is responsible for back pay and loss benefits for the 60-day period that an employee should have received notice of the impending plant closing or mass layoff and didn't. Okay. That can be really expensive if you are eliminating 500 jobs, for example. New Hampshire also imposes additional penalties. This is a civil penalty of $100 per employee per day of violation. Okay, and that can go on for, if it's required to be a 60-day notice, do the math, that's really expensive. In New Hampshire, the New Hampshire Department of Labor can also lien business revenues and all real and personal property of the employer to ensure that the back pay, the loss benefits, and the civil penalty will be paid by the employer. And also, really importantly in New Hampshire, is that New Hampshire has dissolved the corporate liability shield for parent companies of companies that violate New Hampshire mini WARN. And I think this happened in it was the early 2000s, where a company in New Hampshire, I think in western New Hampshire, shut down, failed to provide any type of WARN notices, and then essentially the parent company said, well, that was a separate corporate entity, so we've dissolved that organization. There's no assets left to it anymore. So sorry, we didn't comply with WARN, but we're not going to pay the affected employees anything. That resulted in the creation of mini WARN, and it resulted in a provision in New Hampshire that says, okay, well, you terminated that company or scuttled that company, but you're the parent company, and we're going to come after the parent company for those types of violations and to ensure that the employees receive their back pay and loss benefits. So if you haven't scanned the QR code yet, this is another opportunity to do it. Or if you lost it, take a minute and scan the QR code. I got a couple of hypothetical questions that we can start running through, which will hopefully make this a little more interactive and less of me lecturing to a blank screen. All right. And if you have questions, please put them in the chat. I'm going to address the questions at the end of the presentation while everyone is also looking at the SHRM slide to make sure that you get your SHRM credits. All right, so I'm going to assume everyone's ready to go here. And here's the first question. So large tech company, that's a little vague. Let's say, I don't know, Twitter laid off 4,400 workers in November. Instead of providing WARN notices, it agreed to pay the affected workers their regular rate of pay and to provide benefits for 60 days until January 4th, 2022. No strings attached, meaning that they don't have to sign a severance agreement. They just get the 60 days payment and they get the 60 days of benefits. Is that permissible or impermissible? Ooh, jumping around here. All right, most people said impermissible, and this one's tough because in a way both are probably right. This is a technical violation of WARN, absolutely a technical violation of WARN, but it's likely permissible. So WARN does not expressly contemplate pay in lieu of notice, but there is guidance from the USDOL that says this. While an employer who pays workers for 60 calendar days instead of giving them proper notice technically has violated WARN. So those people who put impermissible, you're absolutely right. It is a violation of WARN. Because WARN provides for back pay and benefits for the period of violation up to 60 days, the approach means that the employer has already met the penalty specified in the act. So in this case, large tech company, Twitter, has violated WARN, but it's, the liability that it would receive under WARN has already been paid or has agreed to be paid by it. So, in all likelihood, there's not going to be a significant lawsuit over this, although I understand lawsuits have been filed, and there may not be robust action by the USDOL. Question 2. Getting into Thanksgiving themes, Turkey Tom has exactly 100 employees. Due to economic constraints, it reduces the hours of 30 employees by 50%. Okay, so we're looking at, all right, is this an employment loss? Turkey Tom expects the hours reduction to last only 4 months. It lasts 6 months. During the 6th month, Turkey Tom terminates 5 employees from its accounting department due to further financial strain. Turkey Tom does not issue WARN notices to anyone. Is this a mini warrant violation? Yes or no? And assume Turkey Tom is in New Hampshire. Oh, evenly split. Give people a few more minutes, but looks like everyone who's going to chime in has chimed in. So this is impermissible. It is a violation of New Hampshire warrant, I would say, although it's a little bit on the fence. So the problem here is the employer reduced hours of work for 50% for 6 months, creating a job loss. Okay, but it only did it for 30% of its workforce. So 30 people, out of 100 employees is 30%. And it was only supposed to be for 4 months, and that made sense. But once that 6 month rolled around, then it became an employment loss under Warren, which again, Warren notices still wouldn't be required in that situation. But what happened was at that 6 month, within that 30-day period, Turkey Tom then terminated 5 other employees to bring the total count of individuals or employees suffering a job loss to 35 employees, or 35% of the workforce. I know it's early, percentages and math aren't good. But in all likelihood, the net result is that this is going to be considered an employment loss during that 30-day period and would result in a potential warrant violation. Now, the reason I brought this crazy question to bear is that in a lot of warrant cases, the issue that comes up isn't so much an employer just forgetting to do a warrant calculus, although that happens a lot. A lot of times it's these compounding employment losses that, if you aren't carefully tracked, can result in warrant being triggered perhaps inadvertently. Okay, so it's your job as HR professionals to keep track of these things and to think, oh, we just did a layoff here. We just did another layoff there. We have all of these people working for reduced hours of 50%. I wonder if this is triggering a warrant violation if we lay off these additional 5 employees from the accounting department. And it's a really hard thing to manage, but it's something that needs to be tracked by the employer, just to make sure you don't have an inadvertent warrant violation from these compounding issues. Before we get there, the mini warrant law in New Hampshire, does provide for the following, though, that if a layoff of more than 6 months, which at the outset, in the example we just had is similar, was announced to be a layoff of 6 months or less, it shall be treated as an employment loss under this chapter, unless there are business circumstances that made that made it unforeseeable, and the notice given at the time the layoff or the reduction in hours happened was enough to alert employees that it'd be reasonably foreseeable that the extension would go beyond 6 months. So in the example I gave you, Turkey Tom, when it reduced the hours of those 30 employees for what was expected to be 4 months, it should have provided notice at the beginning of that reduction that says, we're going to reduce these hours. We're expecting it to only be 4 months. However, here are some of the economic situations we're looking at, and it's very likely that this could exceed 4 months and go into 6 months, and even beyond that. If Turkey Tom had done that, then likely it would have covered itself for any type of warrant violation. So keep that in mind when you're doing a layoff that's only expected to last for a certain amount of time, or you're doing a reduction in hours that's only expected to last for a certain amount of time as well. The next question is, Turkey Tom, again, has 100 employees. In April of 2022, it terminates 25 employees from its Portsmouth headquarters. 100 days later, in July of 2022, Turkey Tom terminates another 10 employees from its Portsmouth headquarters, bringing the total amount of employees to be terminated to 35. Turkey Tom does not issue warrant notices. Is this a mini warrant violation? Yes or no? All right, so 88% of you say no, and 13% of you say yes. So let's look at this. This is something that's permissible. It is not a mini warrant violation. Warrant typically examines employment loss on a 30-day basis, on a rolling 30-day basis. But there is a 90-day aggregate here and a 90-day look back. So and look forward, I suppose. So if two employment events do not trigger a warrant event individually, but do in the aggregate, and they occur within 90 days of each other, the events, when looked at together, will constitute a warrant event unless the employer can demonstrate that the employment losses are the result of separate and distinct actions, and are not an attempt by the employer to evade any type of warrant obligations. Okay, so in this situation, we have 25 employees terminated in April. 100 days later, an extra, I think I put 10 were terminated. Because that's outside of the 90-day window, Turkey Tom is likely safe in that situation. But again, when you're doing any type of RIF, it's not that you just need to look 30 days ahead and 30 days behind. You need to look 90 days behind and 90 days in the future as much as you can, to see if you're going to have any type of events that, when taken together, will be considered an aggregate event that would trigger a warrant obligation. So other type of notifications, New Hampshire employers must report all layoffs of 25 or more employees occurring in the same calendar week to New Hampshire Employment Security, which manages our unemployment benefits in New Hampshire, and you have to make that report within seven calendar days. Massachusetts does not have its own Warren law, or its own mini Warren law, but there is a plant closing law. My understanding is that law, it really isn't funded, or the agency that enforces it isn't funded, but it does require private companies to provide advance notice of plant closings. But my understanding is that the law really doesn't have much teeth to it. So with that, we have the technical, or most of the technical information about Warren out of the way with. I think the biggest takeaway for Warren is just to keep a tracker on what is considered an employment loss, and monitor that carefully so you don't have any inadvertent event that occurs that would result in warrant violations. And then at that point, by the time you realize it, it's almost too late to issue any type of warrant notice. And with that, let's go on to everyone's favorite, separation agreements and severance agreements. So severance is compensation by an employer to an employee in exchange for a release of claims. There are certain claims that cannot be waived. Things that are under the FLSA, so you can't waive overtime, you can't waive your right to minimum wage. Workers' compensation can't be waived. Unemployment insurance can't be waived, and there's claims under the Uniform Services Employment and Reemployment Rights Act that cannot be waived as well. And then there's some others that you can talk to your counsel about. The compensation here is often considered, okay, we're going to pay this employee 1 week of severance for every year they've been an employee with us. I think that's the most traditional way people view compensation. But compensation can also be other things, and it's important to remember that it can be other things. It could be a vesting of stock options. If there's a Silicon Valley vesting style that requires a vesting cliff of 4 years, you can accelerate that for the employee and allow all the stock options to vest. That can be something that the employee is not entitled to. That would be sufficient consideration for a severance agreement. It could also be a release from restrictive covenants. If the employee has a non-compete, or if the employee has a non-solicit, you can release them from that, and that will enable the employee to go and work elsewhere without any restrictions, and that's a benefit to them as well. So just keep in mind that compensation can be other things and isn't restricted to the payment of wages or the payment of benefits. I would caution everybody not to include no rehire provisions when you're doing a severance agreement as a result in a reduction of force, because it can seem to be retaliatory by the U.S. The EEOC and the New Hampshire Commission for Human Rights, and that's because the employee really hasn't done anything; they're just being laid off. So why would you say we're not gonna rehire them unless there's something else going on? I will say this very carefully. Have your severance agreements reviewed by counsel, please, please. And I wouldn't make that plea unless I saw it a couple of times a year. They're really, if you want to see your CFO get just steaming mad, just absolutely steaming mad, do a severance agreement, pay out tens of thousands of dollars to the employee, and then realize a month later that the severance agreement that you created and the money you paid out doesn't actually release any claims and isn't affected or isn't effective. I say it because I see it all the time. Just have them reviewed by counsel. It's really just a best practice. Don't pay out all that money unless you make sure that you get the return that you want, and that is the release of the claims. And finally, severance agreements are entirely voluntary in this situation. You're not required to offer severance agreements, but many companies do because there is that benefit of shoring up liability and ensuring that the company isn't going to be sued. So that brings us to question 4. Mr. Nice Pie Bakery has 15 employees. Due to hard economic times, Mr. Nice Pie is laying off 5 staff members, including Joe, who is 53 years old. Joe receives a severance agreement and is required to accept or reject the agreement in 5 business days. Permissible or impermissible? Okay. 92% of you say impermissible, and 94% climbing up, and 6% say permissible. This is permissible. I know a lot of you are probably thinking about the ADEA, and I think that's the right place to go. However, Joe doesn't have that many employees. The ADA only applies to employers with 20 or more employees. And there is no obligation in New Hampshire to provide any type of consideration period or revocation period for severance agreements. So something to keep in mind if you're working with a small employer or if you are an employer with fewer than 20 employees, you have a lot more latitude when you create severance agreements because you don't have to have the person have that 21-day consideration period. Question 5. Gym and Tonic Fitness is an international fitness establishment that lost momentum during the pandemic and laid off staff. All affected staff members received 1 week severance for each year of service if they signed a severance agreement. For those over 40, the severance agreement must allow for how many days for the employee to consider the agreement? So in this context, how many days does the employee get who is over 40 to consider the severance agreement? You can select your options. Okay. 21 looks like the majority of you say 21 days at 53%. Some say 7 days at 13%. No one put 40 days. No one put 35 days. And then 33% at 45. So this is why you have your separation agreements reviewed by counsel. It's 45 days in this circumstance, not 21 days. This is being offered as part of an exit incentive. And if it's offered as part of an exit incentive program, then the employee must be given 45 days to consider the severance agreement and 7 days to revoke. So those of you who put 7 may have been thinking of the revocation. And those of you who put 21, we're probably thinking of the situation where a severance agreement is offered outside of a reduction in force or outside of an exit program. Okay, now that leads, I think, to the inevitable question is, well, how do I know if an exit program exists? Fortunately, the regulations provide a definition for us. An exit program arises when an employer offers additional consideration for the signing of a release, i.e. a severance agreement, as an exit incentive to 2 or more employees. So if you're firing 2 or more employees, without cause, and it's seen as a way to get them to exit the company peacefully and release any claims, then that is going to be considered an exit program, and you're going to have to provide 45 days of consideration. Again, work with counsel on this stuff because there's the devil's in the details of the regulations, and there may be some options available to you. So, question 6. Back to Gym and Tonic Fitness. To be effective, the severance agreement must include what document? COBRA notice, title and ages of those in the decisional unit, title and ages of everyone laid off, and ages of those affected by the RIF. And again, in this situation, Gym and Tonic is laying off a lot of employees as part of an exit, as part of a RIF, and is asking its employees to sign a separation agreement. Okay. So the correct answer here is B. Everyone in the decisional unit, their ages have to be, well, not their ages, but their categories of ages, I suppose, have to be disclosed. Not just everyone who was laid off, but everyone who wasn't laid off as well. Everyone who was selected and everyone who was not selected to be part of the exit program. You have to provide their titles and their ages. So a decisional unit identifies, it's a list that identifies the ages and the job titles of those selected and not selected for the exit program in that decisional unit. It has to be in writing, and it has to be presented in a clear manner to the employee so that any person will be able to understand it. The decisional unit itself is that portion of the employer's organizational structure from which the employer chooses who will be laid off. A decisional unit can be the entire company. If you're looking at a company-wide reduction in force for your employees, if you only have 30 employees, for example, it could be allocated to a specific facility. A decisional unit could be a recognized department in the company. It could be the marketing department. It could be the accounting department. It could be the engineering department, whatever it is. A decisional unit could be a particular job rank. Okay, everyone who's an entry-level employee, we're going to reduce 10% of those employees. Okay, so that's your decisional unit. Could be based on seniority. Could be based on who reports to a specific vice president. Okay, so we're going to reduce everybody who reports to this person by 10%. Whatever it is, it's the scope of the pool of employees from which you are deciding who you are going to RIF from. Here is an example from the regulations of what a decisional unit list can look like. And the regulations actually say that this isn't the best model, which is interesting, or is that this model isn't necessarily going to be correct, which is not that helpful. But here it's a decisional unit of people within a construction industry. It lists the ages of certain employees. The mechanical engineers, 25. There are 21 of them selected, and there are 48 of them not selected. So again, the person who is being terminated, who's over 40, is able to get some information about how the company selected those who were eligible or who would be laid off and who would not be laid off. And the reason that's important for the ADEA is reductions in force disproportionately affect individuals who are over 40 or into their 50s or into their 60s. And the reason for that is, a reduction in force is intended to save money for the company, and older employees are generally paid more than younger employees, seniority, experience, the like. And so it's been found that layoffs disproportionately affect them. So if you're going to do a layoff, someone over 40 is certainly going to be able to understand or look at this data and say, I look like I was selected because of my age and not because of some other criteria. Or they might say, well, no, look, 21 people who are 25 were also laid off. And there's been 3 people who were there's 7 people who are in their 60s who were laid off. And so that information is important for the employee to have. Wage considerations. The fundamentals of wage and hour law apply in the RIF, layoff, and furlough context. And I see this a lot as well. And I do a lot of wage and hour work. Overtime still applies. Minimum wage considerations still apply. And final wages still apply. If you have employees who are not being efficient enough and they're paid on an hourly basis, the appropriate remedy for that is not to just pay them less or to mess with their hours or to say, this job should have only taken you 5 hours and you billed me for 10 hours, so I'm only going to pay you 5. The appropriate remedy for that is management, okay? Not to start tinkering with with their pay in any respect, because that's going to lead to more trouble down the road. Final wages in New Hampshire, final wages for a layoff must be paid out the day after the layoff. Some of you may be thinking about the 72-hour rule. That's when an employee is discharged from the company, generally either for cause or not cause, but in situations unrelated to a layoff. In New Hampshire, you have to pay out accrued PTO if the employer has a policy or practice of treating PTO as a wage. One way of treating PTO as a wage is to have a policy that says PTO is paid out at the end of employment, or to have a practice doing the same. But just remember that there can be also other ways in which a company treats PTO as a wage. You could have something in your policy that says, PTO is your money, it's our wage to you. And in that case, even if you traditionally don't pay out PTO, then actually I think the law was just amended. So then you're going to be in trouble. In Massachusetts, final wages due last day of employment, and includes payment of accrued PTO and sick time no matter what. Something just popped into my head, and I created these slides last night where I think New Hampshire may have just amended this PTO law. And I'm going to check that after the presentation and send it out with my slides, because I want to make sure I'm having up-to-date information. Okay, so question 7. Mountain View Skiing's headcount fluctuates between 150 employees during peak season and 20 employees during the off season. Janice directs the ski school program. During peak season, she is paid a salary of $1,000 a week. Because Janice works only 2 days a week from August to October, after being laid off from April to July each season, Mountain View reduces her weekly salary by 30% during that period from August to October. Mountain View treats Janice as exempt, permissible or impermissible? Okay, so 31% of you say permissible, and 69% of you put impermissible. And let's see, this is impermissible. Here's the issue here. Janice is considered an exempt employee. And because nothing is really happening from August to October, except for she's working a couple days a week, the company decides to reduce her pay based essentially on the hours that she is working. Okay. And that is a violation of the salary basis requirements for an exempt employee. Because an exempt employee must be paid a salary basis no matter how many hours they work, regardless of the production or quality of their work. And here it is apparent that the company's saying, oh, well, Janice, you're only working 2 days a week. So during this period of time, we are just going to reduce your pay. You can't do that. So reducing an exempt employee's salary based on those considerations jeopardizes the exemption. What Mountain View should have here is a safe harbor policy that might protect it in the event that Janice says, well, I'm not being paid for all hours worked, and it's given the opportunity to correct that mistake. There are very limited circumstances where you are allowed to reduce an exempt employee's salary, and those are in the regulations. One of them is, the first and last week of work, deductions for sickness made under a bona fide plan, etc. But if anytime you are considering reducing an exempt employee's salary, think very carefully about it. Now, this is different than a company saying, okay, we are entering hard financial times here, and as a result of that, we are going to do a 20% reduction in pay across the board for all exempt employees. Now, these exempt employees are still going to be required to work the same amount of hours that they were working before, and it isn't based on the quality of their work or how many hours that they're working. That situation is likely permissible, but you as the company need to be very careful in how that's communicated, because it can't be seen at all to be linked to how many hours the employee is working. If the company were to say 20% reduction in pay and everyone has Fridays off, okay, now you're in a lot of trouble. But if it's just a 20% reduction, you can do that. of course, you got to provide, advance notice ahead of the next payroll period, etc. Question 8. Smoke Fire Brewing is financially strapped due to a hop shortage. To purchase new hops, it allows its employees to use comp time at a rate of not less than 1.5 hours for each overtime hour worked in lieu of a cash overtime payment. The employees love the policy because they get extra time off and PTO. Essentially, someone works overtime. They work 42 hours a week, for instance, and instead of getting 2 hours of overtime, they get 3 hours of PTO. Is this permissible or impermissible? Okay, 8% are at permissible, dropping 7%, and 93% are at impermissible. This is impermissible. And the reason is that compensatory time is permitted only for employees of public agencies. This is a brewery. As much as I would love to see federal money go to breweries, it's not going to happen. So the benefit does not extend to private companies at all. And I do see this a lot, and it's something that can't be done as a private company. There was talk in Congress in 2016 about amending the FLSA to allow comp time to extend to private companies, but it never passed. Nothing ever happened with it. For those employees of public agencies, or those employers who are public agencies here, just know that the employees must be allowed to use the compensatory time on the dates selected by them, unless doing so would be unduly disruptive to agency operations. And we're winding down here. And we're going to talk about people operations briefly. And just as wage and hour fundamentals still apply, people operations principles still apply to all RIFs as well. If you're doing a RIF, so long as it's manageable to do, I still encourage companies to do exit interviews. There's a lot of things you can learn from that. Carefully draft and end of employment notifications. COBRA notifications have to go out. You need to be responsible for consolidating data here. Supporting affected employees, supporting unaffected employees. What's the messaging going to be to those who were not laid off? Monitor and amend job descriptions as appropriate. I'm a massive proponent on having up-to-date, accurate job descriptions. It makes your life much easier in any type of litigation. And also be sure that when you do any type of position elimination or layoff, that you ensure to cut off access to the terminated employees' computer, cell phone, documents, whatever it is, in order to protect the confidential information of the company. So let's go through a question. Alice's restaurant eliminated Josiah and Sarah's accounting positions and consolidated them into a new position. Alice's restaurant didn't hold interviews and hired Sarah straight into the role. Josiah had documented performance issues and recently had been making ludicrous comments to management that under New Hampshire law, gift cards cannot be accepted without valid ID. Alice's restaurant was glad to see Josiah go. Is this a permissible or impermissible situation with respect to the way this was done? Okay, 92% say impermissible and 7% say 93% say permissible and 7% say impermissible. So, answer: impermissible. There is no technical violation here, not that I can see, but the real concern here is it seems like Josiah is being swept up into a riff because he's a gadfly and because he is making complaints to management that would entitle him to whistleblower protection, right? Avoid the temptation at all costs to sweep troublesome employees into a riff. You're not fooling anyone. They can still bring a lawsuit provided that they don't sign a severance agreement, and you're going to have very good reasons for sweeping Josiah into this riff and hiring Sarah straight into the position and not Josiah. Now, those reasons could be that Josiah was just a poor performer and Sarah's better at this new job. That's in the example. I get that. But I think there's a way that you have to go about doing that to try and minimize your risk for litigation. Also, a word of caution on position eliminations. I see this a lot as a litigator as well. Is companies will say, "Well, the position's eliminated. Sorry, we're letting you go," and the person also happens to be a toxic employee or a troublesome employee. And then later on, the position sort of rematerializes, or a position that's very similar kind of shows up again. And this is a quote from the First Circuit that I've often liked, and that is, when an employer defends an employment discrimination case on the grounds of position elimination, the position may not, like a dahlia painting, fade from one image to another, only for the first image to reemerge at the blink of an eye. If you're going to eliminate a position, eliminate a position. But don't eliminate a position to get rid of someone. Wait what you think is a sufficient amount of time and then reintroduce that position again, because it's not going to work. So, with respect to Josiah and Sarah, what should Alice's Restaurant do instead of just hiring Sarah straight into that role? Any thoughts? You can type them in. Yes. So I think people are exactly getting what I'm driving at here. Post a job, do an interview, create a whole process for what you're looking for in this candidate. Interview other people too. I mean, Sarah may be great, but there could be external applicants who are just as good. Then at the result of that, then you have more data to say, look, we gave opportunities to Josiah to come interview. He interviewed poorly. He doesn't have the qualifications for this job. And, be careful how you write those qualifications, because I guess those could probably be problematic as well if you're, deliberately excluding him. But make the process look as transparent as possible and have a transparent process, okay? Because that is going to provide you with innumerable defenses in any type of litigation. Then Josiah coming and saying, well, the reason I really wasn't hired for this, and the reason I was laid off was because I'm a whistleblower here. And you want to arm yourself with as many counterpoints as you can in these types of situations, because they do get messy. So best practices for RIFs. Interview for newly consolidated positions. We just talked about that with Sarah and Josiah. Don't use RIFs to manage performance. Okay, just not a great idea. If you want to manage performance, which you should do, manage it with PIPs, manage it with job descriptions, manage it with expectations. Avoid the temptation at all costs to just sweep troublesome employees into a RIF, because more often than not, they're going to be savvy enough to know that it's really me here, and it's not the RIF. Conduct an impact analysis on all RIFs. Always do that. It happens a lot where an employer has a neutral criteria for selecting who is going to be laid off. Sales department, your sales are below a certain threshold. Everyone below that threshold is getting laid off. Everyone above that threshold is staying on. Okay. But when you look at the disparate impact analysis of it, you find out that compared to your workforce, you are disproportionately laying off minorities, or you are disproportionately laying off older workers. Okay. And that has the air of creating a disparate impact case for you, even though the policy you have is neutral. So take a look at that stuff, because it's vitally important. Use committees to select employees who are going to be included in a layoff. Please never have that decision fall on a single person. And I've had this case before, where one person made the decision to lay off 10 employees, and it just so happened that one of the employees who was laid off was really butting heads with that employee, and then brought a lawsuit saying that he was a whistleblower and that he had reported to that one person some type of company violation, some type of legal violation, and that was the reason he was swept into the RIF. Now, think about that same case where you have a committee of 6 employees, 6 executives, 6 whomever, who are deciding who is going to be included in the layoff and who is not going to be included in the layoff. It's a much harder case to argue that all 6 of those employees, all 6 of those people on that committee we're hell bent against getting rid of that one employee. So use committees to select who's going to be included. It minimizes the risk of litigation, or at least provides additional defenses. And create a plan for a RIF. Establish the criteria of who you're going to consider, what type of decisional units you're going to consider, how you're going to make these decisions, and then document that process as thoroughly as possible as to how these decisions were made. Okay. Finally, as we saw at the beginning, I think the word cloud, the word that came up the most for reductions in force and RIFs and layoffs was sad. I think the other one was difficult. The other one was painful. There are options that are available to companies to not do a RIF. Understand you sometimes they have to happen, but before you go down that road and potentially expose yourself to liability under a warrant situation, or have to start drafting severance agreements, or get into a situation where troublesome employee is swept up into the RIF, think about alternatives. Some of those alternatives can be unemployment work share programs. The state of New Hampshire has one where you're allowed to reduce employee hours by a certain percentage, and those employees are then able to get unemployment benefits to help make up the difference. Okay, those programs I think were used a lot in COVID, still around, still a vital tool. Reduce pay where possible. Do furloughs or temporary layoffs. The office is going to be closed on Fridays. And review compensation plans. It could be the case that the way you've designed your commission plan is paying too much in overtime, because overtime is only going to be that halftime premium and not 1.5 times for a commission. Or consider other things like the fluctuating work week. There's all sorts of ways to redo it, but review those plans. Make sure you're on the right side of the law, of course, but see if you are paying too much for certain things. And of course, budgeting is another great tool as well. So the last one here is just a survey. How'd you hear about the presentation? Just helpful for our marketing department. If you want to fill it out, great. If not, then we will move on to the questions, and make sure I put up that slide for everybody. I'll just give it a minute here. Looks like I got a few more coming in. All right. So thank you for completing that. Thank you for coming to this morning. I greatly appreciate it. And here is the credit slide that I have long since promised. That information, use the code, use the link, make sure you get your SHRM credits for this presentation. And with that, I'm going to start addressing some questions where I can, and feel free to hang around. So one question from Gail. Hi, Gail. I think this relates to the Mountain View example I gave. Is they should have switched her to a non-exempt status, and it would have been okay, right? I think that's possibly one situation, is where you have maybe not a non-exempt status, but you have two job descriptions. One job description is where the off season and you're paid on an hourly basis. The other one is during the regular season. It still doesn't give me much comfort unless the duties are significantly different between those two, because then it just looks like you're just trying to pay the person less for not working all hours. But it's an option worth exploring for sure. Steve Davis asked, but if you have clear documentation on poor performance, does that not reduce your liability? And I think that's related to the Josiah question. Yes, it does reduce your liability. It certainly gives you a defense to litigation. I think another defense is to say, and we opened it up to all employees to interview for this position, and we opened up to the larger job market. And Josiah, legitimately just did not get the job here. We gave him the opportunity, but he just didn't succeed. Uh, I like having both of those defenses rather than just there was a decision made behind closed doors to put Sarah into this position, and Josiah never even had the opportunity. So that's why I would recommend at least opening up to the interview process. And Steve had another question, posted it internally and externally to be transparent and fair. I think that's in response to the other question I had posted. So with that, thank you so much for coming to the presentation today. I hope everyone has a happy, healthy, and safe Thanksgiving. Get your SHRM credits, and we'll see you back here in December for the top 10 wage and hour violations. Thanks so much.